job was to make sure Floyd was restrained until the paramedics arrived. He hit points such as that Talbot Floyd possibly was faking or feigning that he couldn't breathe, that he seemed to be under the influence of drugs, maybe had excited delirium, and that Tal knew the ambulance was on the way. In fact, he upped that code that to emergency lights and sirens so that the ambulance would arrive quicker. Ultimately, his defense was focusing on that willfulness standard, saying that there was no bad purpose or improper motive to disobey or disregard the law when Tal was just performing his duties, Michael.
This seems to me to be the one area where they might run into some trouble here. What about Lane and King? What did their attorneys have to say?
Their attorneys didn't take quite as long to summarize their cases. Former Officer King's attorney was passionate at times and very vocal. He focused on the theme of inadequate training, the lack of experience with King being a rookie, and his perceived subordination to Chauvin, who was a 19-year veteran of the force, the most senior officer on the scene, who took over what they were doing with George Floyd. And he also pointed to this confrontational crowd as a factor as to why King really had his hands tied in what he did or didn't do in that situation. And then, of course, former Officer Lane's attorney, Earl Gray, who we're quite familiar with, was boisterous in that he was focusing in on this deliberate indifference, because remember, Lane only faces one of these counts of failing to render medical aid and showing deliberate indifference. So he was telling this jury that Lane, not once but twice, asked to roll Floyd on his side, and Chauvin didn't just say no, Michael. It wasn't a maybe, it was a no, it was a don't talk to me sort of no, is what he said. And that it was brave for Lane to even speak up to a man like Chauvin with 19 years and a field training officer in that situation. And that ultimately Lane was concerned about those medical needs. And Grace just basically urged the jurors to question why Lane was even in the courtroom and charged in the first place, given the extent he did go to, according to his attorney, to help George Floyd.
All right, this jury has a lot to consider. Chanley, remind us of the jury makeup.
Sure, this jury is a diligent jury based on these poll reporter notes we've been scouring through for the limited access inside that courtroom. There are 12 jurors and 2 alternates now, Michael. 4 men, 8 women. The 12 who will be deliberating all appear to be white and have diverse backgrounds as far as careers and ages, and accountant, architect, computer programmer, and they definitely have their work ahead of them tomorrow.
All right, and quickly, you've touched on it a few times, but just remind us, what exactly are the charges being considered?
There are 2 counts this jury will consider. The first is that failure to intervene that I mentioned, and that's a count that only former Officer Tal and King face for willfully failing to intervene to stop Chauvin's use of that unreasonable force. The other count is that deliberate indifference all 3 former officers are facing because they did not offer any medical care or aid. They willfully failed to aid George Floyd. Now, the prosecutor spent a lot of time going through these counts and all the elements for them, Michael, and made it pretty simple. Here's what the prosecutor argued that they had to show. First, for failure to intervene, they have to show that the officers knew the force that Chauvin was using was unreasonable, and they had a duty to stop it, and they didn't. For the medical aid failure, the officers knew that Floyd was in distress and did nothing. And they, according to the prosecution, that's enough to show that willfulness standard here. So again, once this jury is instructed on the law and applies it to the facts, will they be able to meet that high bar of willfulness in this case?
Yeah, and the jury expected to get the case tomorrow. Chanley, thank you so much for that report. Appreciate it as always. We're going to take a break now. When we come back, some dark revelations revealed inside a Michigan courtroom today. Prosecutors say accused Oxford High School shooter Ethan Crumbley was calculated and enjoyed his dark side. We're going to take you inside that courtroom next. So keep it right here on Click TV.